Right, so as I mentioned at the start of the bulletin, we are joined by Steve Ogolla, an advocate of the High Court, and another advocate coming to us from across the pond, and that is Waikwa Wanyoike. Oh my goodness, Waikwa, your name keeps tripping me up. So I'll start with you, Steve. What's your reaction to that political reaction to the High Court's declaration that the BBI process has been unconstitutional?
I think we knew that the politicians would bastardize the judiciary if the ruling goes in a way that they did not anticipate. I'm talking about the political the promoters of the BBI. Again, we know that our politicians, the only time they get to support court judgments is if those judgments favor their predetermined political viewpoints. If court judgments disfavor them, then they are known to criticize and bastardize the judiciary. So that's not hardly surprising. It is disheartening, but hardly surprising. But I think I want to caution the public against looking at this judgment through the lenses of revisiting the president's alleged revisit. This is a pure technical approach, analysis of the law and the evidence, and the court have rendered a very sound judgment that was powerfully rendered. And I don't think you can see politics in the judgment the way some Weshimios are trying to suggest.
All right. So, Waikwa, I'll ask you to come in at that point. What's your response to that reaction by the political class?
Thanks. I identify with what Steve is saying, but a few things. One, it's quite telling that in that press conference by BBI Secretariat, it seems like none of their key lawyers, politicians were there. So it's quite telling that if the people communicating about appeal for such a consequential decision and you're getting your legal advice from Junet Mohammed, Maoka Maore, Wambugu Ngujiri, and your lawyers have ducked, that should say something to Kenyans. That's one. The second point is it's very, very unfair to accuse the judiciary of getting into an unholy alliance. You go to the 321-page judgment. The judges spend about almost 150 pages explaining what the parties told them. Those things are in court record because they're in documents. And then they use that information to do their analysis and keep cross-referring to that information. So where is the unholy alliance? And it's also quite interesting that in 2017, the people who are alleging that civil society was in an unholy alliance with the court when the presidential election was nullified are now on the opposite side. And the ones who are being accused of being in an unholy alliance, the Junet Mohammed and such, are now the ones making the same accusation.
All right,
it's
quite
really
telling.
Cheap politics.
Quite telling indeed. So are the political class falling back on old tropes? Let us know what your thoughts are. The handles are at NTV Kenya, at Obaruz is my Twitter handle. Steve, what's your Twitter handle?
At Steve Ogolla Law.
At Steve Ogolla Law. Waikwa, are you on Twitter, and what's your handle? Waikwa, did you hear me? All right, while I establish what...
I'm having difficulty hearing you, Olive.
All right, we'll sort that out, and then once I have a chance to speak to him behind the scenes, I'll let you know what his Twitter handle is as well. We take a break. When we come back, now we delve substantively into that judgment. First, we'll take a look at the highlights of that judgment, then get into things with the two advocates on our panel tonight. Thank you for staying with us on NTV Weekend Edition. Now, before we delve into the finer points of the High Court ruling on the BBI process, let's first highlight the court's findings. They found that there are fundamental aspects of the Constitution that are protected from amendment, that it requires sovereign, primary constituent powers to amend them, and that involves, among other things, civic education. We'll be getting into that with the advocates and what that means. That the amendment by popular initiative is the preserve of private citizens. Therefore, the president had no business claiming that the BBI is a popular initiative, that the president can be sued in his personal capacity, that the BBI steering committee is an unconstitutional entity, that President Uhuru Kenyatta fell short of Chapter 6 of the Constitution on leadership and integrity, that each of the amendment clauses ought to be presented as a separate question, that it cannot be a wholesale yes or no. You must know when you're in the voting booth what you're voting yes or no to. That while the number of constituencies can be altered, the procedure by which it is done is protected. That means the role of delimitation belongs with the IEBC. That the IEBC cannot oversee a referendum, one, for lack of quorum. That they ruled that they need a minimum of 5 commissioners. 2, that they will be required to conduct a national voter registration to ensure that nobody is disenfranchised, meaning nobody who has turned to the majority age is left out. 3, because there is no framework in place for signature verification, the IEBC was not in a position to conduct a referendum. All right, and those are, I think, 13 points that we've highlighted from the judgment. And now, as I mentioned, we'll get into the details of it with Steve Ogolla and Waikwa Wanyoike, who is joining us via Zoom. Waikwa, I hope you can hear me better now. Well, it appears we still need to sort something out there. All right, so Steve, yes, I come to you.
Yes.
What is that sovereign power? What was it? The power that's required to amend these protected provisions of the Constitution. What is that about?
Well, it just means that whereas MPs can undertake a process that can culminate into an amendment of the Constitution, because that is what is allowed under Article 255(2), if that amendment goes to the core of the Constitution, and the core of the Constitution means there are certain provisions of the Constitution that reflect our history as a country. They reflect the journey we have walked, which is over 20 years in terms of the quest for transformation of our architectural setting for our constitutional framework. So the court said, if you want to alter the protected provisions, then you have, in layman terms, you have to involve the people every step of the way. And you cannot just window dress the process. You cannot decide in a boardroom, in an executive boardroom, that you want to alter the Constitution and then you give it some flavor of political legitimacy by involving people at the tail end. So if you talk about the constituent power, it means the power to alter the fundamental aspects of the Constitution must originate from the people. That is what the court says, and it's a reflection of a more than 20 years journey that you've had to get this level. But I think it's important to note there are some provisions in the Constitution that are not protected, which means they're easy to change. For instance, Parliament has been struggling with implementation of the 2/3 gender principle. If you look at Article 177 of the Constitution, it provides that in the National Assembly, you just top up, you nominate the win. But if you look at Article 97 and 98, in respect of the National Assembly and the Senate, that formula does not exist. And therefore, the Duale Bill, the Sijenyi Bill have been proposed, and the efforts have been made previously to try and top up. That kind of beneficial improvement or changes the Constitution does not always require referendum. But if you're going to change the structure of governance, you're going to alter the design of the Constitution so fundamentally, then the journey that led to that process, that provision being enacted, you must retrace that journey. You started from the people, then you went to, in terms of civic education, then you appointed committee of experts to look at it, to collect these views, and then you drafted a bill, and then Parliament approved it, then it went to a referendum, then you must start afresh from back to the people. That is what it means to recognize and respect the constituent power of the Kenyan people. Okay.
Waikwa, did you catch that?
Yes, I got all that.
Okay, but where did these requirements come from, right? This civic education, this is public participation one of them? Yes, I think it is.
Yes, I think if you look at the Constitution Review Act 2008, and the Constitution Review Act of 1997, and as amended in 1998, there is an inbuilt mechanism therein. It says, so first of all, you have a special legislative framework that provides for critical steps that must be complied with or must be followed if you're going to change the Constitution in a fundamental way. Those two acts say, for instance, number one, that you have to conduct massive civic education in the first place. Then in the second place, you need what you may consider as a constitutional review commission. You know, actually to oversee and maybe to conduct and oversee the civic education. Then once you've collected and collated all the views emanating from the ground, or maybe from the people, maybe in our context from the wards, from the constituencies, even from the counties, then now all this feeds into a bigger national constitutional conference, where then people have an opportunity to go through all the views that have been collected, and then the committee of experts, if you like, will then draft a constitution amendment bill, which is then taken to Parliament. Parliament will look at it and approve it without altering the key aspects of that bill, and then it is subjected to the referendum. So the court already delineated a four-step procedure. You have to have a constitutional review commission, if you like, maybe in the format of a committee of experts. Then you have to have pervasive or maybe extensive civic education. Then you have to have a draft bill. Then you have to have the referendum. You cannot start from the boardroom that you decide these are the changes that you want, and then you work backwards. I think that is what the court is rejecting, and it's a process that you're already too familiar with. All
right. Waikwa, you can understand, perhaps, it sounds like a very, in my non-legal opinion, a convoluted, a bit complicated process, because I thought the Constitution set it out quite simply. Somebody makes a proposal or a suggestion. That proposal or suggestion evolves into a bill, right? They collect 1 million signatures. It goes to the IEBC. IEBC verifies that we have a million plus signatures, and then takes it to the county assemblies. Once the county assemblies, it's within 3 months, right, consider it and pass it according to the requirements therein, as far as the number of county assemblies is concerned. Then it moves on to Parliament, and once it moves on to Parliament, then from then it's, if they approve it, right, or if at least one house approves it, then it moves on to the president, and that's where we thought we were, who is then required actually, because it says shall request the IEBC to conduct a referendum in 90 days. So Waikwa, please educate those of us who are now not familiar with all this business about civic education and committee of experts. What did we miss?
So what the court is saying is that there is a difference between amending the constitution and making a constitution. And to some extent, first of all, just to explain, when you make a constitution, you're not actually bound by the rule of existing constitutions. You're starting from scratch. So the point that Steve was making is a law is made that will guide the process of making a constitution, which then the court says the qualitative way to do that is to have very extensive procedures, the four-part procedure. That's the first point. The second point is that in our current constitution, there are different types of provisions. Some provisions can never be changed using amendment, constitutional amendment power. And those are the provisions that require the procedure that Steve was explaining. The reason because the power to amend the constitution is a power that is contained in a constitution. The power to make a constitution or to create the structure, the basic structure of a constitution, is power located actually outside the constitution. It's power that stays with the people as the people. So, for example, when we were making the 2010 constitution, we were not working under the rules of the 1969 constitution. The reason why the court makes a distinction between what it calls the basic structure provisions, all aspects of a constitution, from the rest of the other provisions of the constitution, is because if you take away those basic structure, then you don't have a constitution. So, for example, can you have a constitution that says you will not have a parliament at all bodies of governance?
Mm-hmm.
Can you do that? So that's a basic structure. Can you have a constitution that says you will not have an institution to do dispute adjudication, which is the judiciary? No, that goes into the basic structure. So that's why the court is making a distinction between provisions in the constitution that are protected
mm-hmm.
and provisions that are not protected when it comes to amendment.
All right. My next question then, Steve, is this: when we go to a referendum, is that not then the people exercising that sovereign power?
I think the purpose of the referendum is to validate that which they have participated in. And I think I agree fully with what Waikwa said. If you're going to alter the constitution in a fundamental way as to change its character and form, then you have to start from where the people, you have to start with the people and then again terminate at a referendum where the people again validate. So the thing is this: what the court is saying in terms of the protected provisions of the constitution, there must be a prior conversation about the intended changes before you can now enter or come within the purview of Article 255 or within the purview of Article 257 or maybe 257, 256 and 257. What that means is, if you want to alter the constitution, let's say for instance, our constitution recognizes and requires that we uphold judicial independence as part of our critical constitutional safeguard for our judiciary. If you want to alter that, there has to be a separate conversation happening out there. Out there means it's a conversation that is happening outside Article 255 before it comes within the Constitution, which means let there be a conversation. Do you really want a judiciary that is powerless, a judiciary that looks behind its shoulders to see if the executive is watching? Do you really want to have a parliament that does not have independence from the executive influence? Do you really want to have the prime minister again drawn from parliament and so on and so forth? Once this conversation has been had out there, then now, and people understand, then now you can begin to trigger the process. So what that means is, in terms of constitutional amendments and the areas that go to our basic structure have already been outlined in Article 2551. Those areas, you must have a detailed conversation and consensus building. Then now, once it has been approved and then it's been reduced to a bill, it again comes back to the referendum so that the people can approve. Because if you leave it to Parliament, you will recall what happened in Naivasha and Kilifi after the Bomas draft. What happened after the Bomas draft, the Yash Palgai team, MPs altered the original document that was finalized at Bomas, and they inserted some clauses there that Wanjiko, meaning the ordinary Mwananchi, did not approve of. So if you don't take it back to them, then so that they can confirm that this is what they have finalized and this is what they are voting to approve, then if they see that the document is different, they will vote to reject. And that has happened in 2005 with the Wako draft, because the Wako draft differed significantly from the Gai draft. So I think the context is, I know there may be some confusion there because the people will have a chance, quote unquote, to vote at the referendum, but the people, when they are voting at the referendum, they should be expecting a document that they participated in robustly and fully in its generation. Okay. Not a top-bottom approach. Not a top-down approach, but a bottom-up approach.
Okay. So, Waikwa, we're taking a break, but when we come back, I'd like you to address this. Why does that task force, the BBI task force, why didn't it qualify, or why did the courts not consider it as a committee of experts? And it could also be said that before this task force presented us with a report at, I'll call it Bomas 1 and 2 with regard to BBI, they brought it to Bomas, did they not? And before they brought it to Bomas, they spent taxpayer money telling us they moved around the country, getting views, collecting views. And also after they went back, following Bomas 1, they went back, came back again, Bomas 2, and presented the recommendations to us. So weren't the people involved, or is that not public participation? And And again, when we come back, I need you to tell us why this task force did not qualify as a committee of experts. So we're going on a break, but when we come back, those questions will be answered. In addition, I am joined by two advocates, Steve Ogolla and Waikwa Wanyoike, who is joining us via Zoom. And it is now, let me see how many hours, 24 hours about, since the landmark ruling by 5 High Court judges dismissing the Building Bridges initiative and basically ruling that it is null and void. So we asked Kenyans around the country what they thought, and here are their views.
Na bado tunasema Mungu amesikia maombi yetu. Sisi wajiko sasa tulikuwa tunanyanyaswa na hii mambo ya BBI ambayo hata kuna wajiko hata mmoja hapa mkaaji wa Mukoyo na Muranga hajaisoma. Hakuna mwenye ameisoma. Sasa tulikuwa tunasema hakuna vile tunaweza abiwa tupitishe kitu hatujui na ni akuja itunyanyase tuongezewe taxes na mago mingi.
Mzigo ya mwananchi sasa tunataka tupunguziwe mzigo badala ya mambo ya BBI, wacha serikali tu ikae vile iko. Uhuru aanze mambo ingine, aunganishe watu kwa sababu saa hii watu wako na njaa sana, corona iko, watu hawana kitu kwa mfuko na anataka kuongeza viti mingi kwa serikali na vile mnyonge saa hii anaumia.
Mambo ya jana kidogo haikunifurahisha kwa sababu kwenye inaendelea Kenya inakuwa ni kama mashindano. Yaani kati ya viongozi na wananchi na watu wengine.
Sioni hiyo kitu kama itaenda through ama kama watakata rufaa ama kiapili, kwa sababu hiyo majaji 5 wamesema ili iko kwa katiba. So wasipoteze muda wao kwenda kuapili hiyo ruling.
Sisi tuna furaha ambayo hatuwezi kuieleza. Kwani Mungu anayeishi juu mbinguni ameweza kututetea na akaweza kutuangamizia hili janga la BBI.
Naamini vile walisema na vile waliamua ndivyo Wakenya wanaendelea kuamua huku chini, but hatuna nguvu. Hii BBI haistahili kuwa ya watu wawili. Hii BBI si ya maana kuliko COVID, kuliko maisha ya Wakenya. Hii BBI ni kutupa.
Naliunga mkono kwa sababu kuunga mkono hivyo ni kuwa hii BBI tumeletewa kweli ni nzuri, kwa sababu sisi kama Kilifi County kwa tunapata maneno bunge manne, lakini sasa tunaona ni kitu ambacho kimeletwa ghafla, yani mpaka tuashtuka, alafu chafosiwa wengine mpaka walikuwa hawasupport ikabidi pia waanze kusupport. Sasa tuwashangaa hii kitu mbona ina haraka, lakini ingekuwa ni kitu labda kingechukua muda, yani tuelezewe vizuri uzuri wake, pole taratibu, kila kipengele kwa kipengele.
Do give my support and I thank the judges for not being interfered by the executive.
Nikiongea hii High Court ya jana judgment yao, mimi nimesikiza yote na walikuwa kwanza very sober na very accurate, na hawa wameilinda katiba ya Kenya.
Raia kama akina mama tulishukuru sana mahakama yetu jana, kwa sababu tulipata tena kuamini mahakama, kwa sababu kama mtu hawezi kufuata process mzuri kwa kitu, raia amekuwa akinyimwa haki yake mara mingi.
Tunashangaa ni kwa sababu ya nini tunakuja kurushiwa tear gas tunaposherekea katika uwanja. Hatukuguza kitu ya mtu, hatunjaribu chochote, ni kufurahia tu kusema kwamba tunashukuru Mungu kwa sababu amesikia maombi yetu. Tear gas ni ya nini?
A lot of people there are saying we thank God, including the Deputy President on Twitter. What do you make of those reactions?
I think this one exposes the displeasure of Kenyans because it seems that people are making decisions on their behalf. And that is the kind of approach that the Constitution discourages or even disallows. But I think, allow me to make a comment only. If you look at the original intention of the handshake through the lenses of the 9-point agenda, there is no way you'd have known that the 9-point agenda would culminate into a constitution amendment bill. Because the 9-point agenda was talking about practical issues that affect Kenyans. Ethnic antagonism, election management, shared prosperity, devolution, and so on and so forth. I think the point is what Kenyans received, and remember, if you contradistinguish the views of Kenyans now and the views of Kenyans post the handshake, immediately after the handshake, there was a lot of excitement because there was no tension, and people said, can we then have a sober, dispassionate, rational conversation that helps us deal with the problems that affect us without necessarily tinkering with the Constitution? Because part of our problem in this country, as with the past, is that you have a constitution, but the implementation phase is so shortened. Before you start implementing, you want to alter it. So somehow, someone decided that this conversation need to take a different trajectory, and they generated a BBI, the BBI amendment bill. Yeah? So then to sanitize that, to give it some flavor of political legitimacy, the task force was gazetted. Then the task force decided to work backwards. That is what you may consider as an afterthought and a clever maneuver intended to sanitize a process that was otherwise not supported by the law. But I think Kenyans and the court remained vigilant, and the court was able to read in between the lines and say, no, wait a minute. The fact that a task force was gazetted and public resources committed to it, it cannot be a Wanjiko-driven process. In any case, look at the JLAC Bill 2020, the Justice and Legal Affairs Committee, their own referendum bill. If you look at the procedure there under that bill for initiating an amendment through the popular initiative, there is no executive intervention, and there is no opportunity to use public resources in that bill that was being considered alongside the BBI bill. So I think the bottom line is this. We altered and hijacked the original intention of the handshake.
Okay.
And I think the handshake itself is not a bad thing, because you cannot delegitimize a political conversation.
Okay.
Conversations bring solutions, but we want those solutions to be framed around the existing legal framework without trying to address the problems and trying to blame the law.
All right.
I think we have said overinvestment in the law sometimes is part of our problem, because then it shields us from accountability. We tend to blame the law more.
All right. Waikwa, your reactions to the Kenyan reactions, and then also I had asked you that question of the task force. Why did they not qualify as a committee of experts? And also, when they went out to collect views, wasn't that now a people-driven process?
Yeah, so 3 points, I think. One, just a quick clarification on why the judges make the distinction between the kind of amendments that can go into the Constitution and the ones that can't. What the judges are saying, because this is very important, is you cannot use the power to amend the Constitution to replace the same Constitution. Remember, BBI proposes to change provisions in at least 13 chapters of the 18 chapters of the Constitution. When you think about it, you can actually use amendment power, and only maybe 2 times you will have completely changed the Constitution you had in 2010. That's what the judges are saying. You can't do that. Amendment power is supposed to just tweak small things or specific provisions, not half of the Constitution or the entire Constitution. To Kenyans, you know, we don't give enough credit to Kenyans, especially when it comes to their appreciation of the law, and especially issues to do with constitutionalism. If you listen very closely, the themes you got from Kenyans is, why are we being rushed? Why is this being done this way? They talked about kwa nini wanafanya hivi kwa ghafla? Kwa nini hawatupatii muda? So they are reading mischief, and that is exactly what BBI is about. Rush everybody through, pack an amendment bill with so many issues. The judges, I think, counted 74 different issues, then tell you that you will only be given 1 question, not 74 questions. And even if you like 20 things out of the 74 things, then it's up to you. You just only have 1 choice, which is obviously unacceptable, because they're just trying to pack or to sugarcoat a poison pill and forcing you to take it. The third point relates to your question about the task force. 2 things. One, the point about who has the powers to amend or who has the ability to change the Constitution through popular initiative. The court was very clear. It's only the people, not politicians in their formal capacity, not the president in his official capacity. And the problem is the president cannot metamorphosize from being president to just a citizen when it comes to constitutional change. No, because the president will still use state resources even if he pretends to be doing it as a citizen. Has a responsibility to foster national unity. On one side, he can't be the one pushing this amendment, and then on the other side, he waits for the amendment to go through the conduit and be the referee to say, oh, are we going to send this to a referendum? No. Okay. The second last point on the committee itself. Who was the committee? How are those people chosen? What are their expertise? Do we know? Do we know how Paul Mwangi, for example, ended up becoming a member of that committee? Yusuf Haji, Wako. That is the transparency that even the Constitution demands. So even assuming the president had powers to appoint a committee, he still needed to follow the law when it comes to transparency and competitiveness and merit.
All right, Waikwa. So, Steve, when we come back from this break, perhaps you can tell us, can they now circumvent, that is the proponents of the BBI, can they now circumvent a referendum and say they have a super majority and now we're just going to go ahead with the amendments that we wish? That answer after this break. Thank you for staying with us on NTV Weekend Edition. Steve, I asked you a question before we went on break, and that is, can the proponents of the BBI now circumvent a referendum?
Can they try? Yes. Why? Because our political leaders prefer to operate outside the Constitution, but within a framework of impunity. Will they succeed? No. Why? Because Wanjiku has become more vigilant, and we are likely to go back to court if we see some clever maneuver or a clever attempt to revive BBI through the back door. So the short answer is there will be attempts, and already Honorable Junet has signaled that. But I want to also advise them that they will not succeed.
Okay. Yes. Waikwa, President Uhuru Kenyatta's administration doesn't have the best track record as far as fidelity to the rule of law is concerned. There are several judgments that have been issued and ignored. So what does that bode for the BBI process?
This one they can't ignore, Olive. It's just too tough for them, and I'll tell you why. One, the judges really explained, and so many Kenyans listened. From what the Kenyans you sampled, you can tell they listened to the explanation. So Kenyans know there is a logical reason why the court actually said what it said. Second, they've already said they respect the court, and so they will appeal. And so they have to subject themselves to that process. The courts are not going to return a verdict in 2 days. Courts take time to decide cases. These cases were filed last year, and in fact, these were fast-tracked. So even if the Court of Appeal was to move very fast, we are still looking for at least 2-3 months before the Court of Appeal decides. And this matter will go to the Supreme Court. Where does that leave us? It leaves us at the end of the year. When is the elections? August 2022. Not every politician is supporting this BBI. So the person who will be left holding the BBI bag and yet wants to be president is Raila Odinga. Ruto and other politicians who are looking to be president will be campaigning for the president. How stupid will you be to be campaigning for BBI, which you don't know that it will ever pass, when your competitors are campaigning for the presidency? And in any event, even if the law passes, now you cannot even use most of that law in August 2022, including the constituencies. You know, what happens is that they say the law moves fairly slow, but catches up with those who think they are too smart. this is one of those moments.
All right. And Steve, now that they're looking at the Court of Appeal, there was reference made when Martha Koome was being interviewed for the post of Chief Justice by the Judicial Service Commission, and they made reference to a certain ruling that was delivered in 2017 at night. Yes. And there are also questions which were raised by the President himself, as well as Deputy President William Ruto, on the Supreme Court's integrity, right? And now we see Martha Koome, who's coming in. And she talked about, you know, wanting there to be room to sit down and have tea with the Speaker and the President, and people not assume that they're discussing court cases. So there are those who could view that as an attempt to appease the executive. And then we have William Oko, who only today, after being nominated by the Judicial Service Commission, was appointed as Supreme Court judge. There are those, perhaps, even after Junaid spoke and he talked about this unholy alliance between the judiciary, civil society, and Tanga members of parliament, already doubts have been cast on the independence of the courts. Though the High Court may have upheld that independence, can we trust the Court of Appeal and the Supreme Court to do the same?
I think there are two issues, and one is really, really disturbing. You cannot approbate and reprobate judicial independence, and Kenyans must decide. And, you know, we say this, I mean, with tongue in cheek, at, you know, the Court of Appeal will sit at night. I think let us stand with the judiciary and let us only expect the judiciary to do that which is right. Now, let us distinguish the sitting in the night the other time and this one. It's very unlikely that a Court of Appeal, if they get a bench, will sit in the night. I think the exceptional circumstances at that time were explained by Lady Justice Martha Koome, and in any case, it was the President of the Court of Appeal at that time, Justice Kihara Kariuki, who is now the AG, that made that call. But be it as it may, we don't anticipate the Court of Appeal to just, without a reason basis, to just set aside all the prayers, all the orders that were given by the High Court. They must give a logical, rational explanation or justification for their decision. But also, it is not possible, practically possible, to reverse all the findings made by the High Court. For instance, you may say that the High Court misappreciated or misunderstood public participation, and then maybe allow that. But how then do you allow the fact that the BBI bill attached 70 constituencies? You know, you can't, you know, if you want to share the power to divide constituencies, then first of all, you must ask the people to validate the decision to share. Then you come back to the table afterwards, then begin to share the role of delimitation of constituencies. So it's very likely that one of the questions that were determined by the High Court will be upheld by the Court of Appeal. Once the Court of Appeal upholds one question, then the entire bill still collapses. Because then the bill shall then have to start afresh. So I think there's really, you know, here's the thing. There are matters that do not qualify for appeal. And I can tell you, I've read the judgment. I read the judgment, the whole of that judgment today. And I can tell you that this is a judgment that is best left to rest. Appealing it, maybe it's for political clout, if you want, or maybe for humor, or maybe for some undisclosed political interest. But to appeal this judgment and have it overturned on the merit is a fool's errand. It's a near practical impossibility. I don't think there's any rational lawyer who will tell you that this appeal has chances of success. So whether the Court of Appeal sits in the night, and I think they won't sit in the night, or not, the matter should just be allowed to rest.
All right. So, gentlemen, allow me to say thank you very much for taking the time to speak to us this public holiday on this matter. The judgment was lengthy, went all the way from about 4 p.m. to 9 p.m. So there's a lot to delve into. We could only delve into so much this evening, but as the days progress, we shall continue to do so. So thank you very much, Steve Ogolla, Advocate of the High Court, and you, Waikwa, as well, Waikwa Wanyoike, who's speaking to us from the United Kingdom. All right, sports news after this break.